This is the Hankins matter, 24-336-13, Heather and Kevin Hankins. And Miss Stewart, you represent Mr. Hankins, correct?
Yes.
And is he present?
No, Your Honor, he had to work today.
Okay.
So
And
I'm
then
appearing on his behalf.
Miss Hankins, can you state your name?
Heather Hankins.
All right, thanks. So this is on for kind of a review of financials. The Mr. Hankins, I know, had been out of work. He had been on disability. During part of the time, he was collecting, unemployment and disability and stuff from the union, yada, yada, yada. Then that ceased. However, he still wasn't back to work, but I saw the material submitted. It looks like he's now back at work, albeit on a reduced load. But so we're here because things have been set over because I didn't have all the information, and we had indication that Mr. Hankins may be starting work shortly, and it looks like he has. So I'll turn it over to the parties to see, what everyone's wanting and doing. I did get the materials. A bunch of stuff was filed by Miss Hankins, and then Mr. Hankins filed, like I said, that letter and the one page. We only got like one pay stub, maybe two. So who'd like to go first? Miss Stewart? On just where we're at, I guess.
Yes, Your Honor. Well, I think that this was technically Mrs. Hankins' motion, so I will yield the floor to her.
Well,
Thank you.
And I guess I wanted to first find out, what is it that we're doing? Is it all the financials? Is everyone ready to go forward? Because we now we have some addition. Because before it was like we didn't have the info. So Miss Stewart, you filed some stuff. You're ready to proceed and
yes,
go.
Your Honor. I'm ready to proceed on I believe we've got, the court has to make a determination about the division of debts. I think at this point, that's probably the least priority in terms of the issues the court has to decide today. Cause I think spousal support and attorney's fees are probably the most pressing thing.
Yeah. That's what
Because I filed January 29th of 2024 for temporary spousal support. So that's kind of what I've been waiting on.
Okay. Well, let's deal with spousal support and attorney's fees, and we'll go from there. So Ms. Hankins, and I know that's the main things, rather than the parties have been kind of dealing with the debt a little bit, and that'll probably wait for another day or see if you guys, I know you got a settlement conference coming up in like a few weeks. So.
Yes.
Okay, go ahead, Ms. Hankins.
Well, you had the information in front of you, and I've given you everything I need, or I've given you everything I think you've asked for as far as where I am and what I've been responsible for. I'm confused by some of the things that Mr. Hankins submitted because they're not, I understand that he had surgery and he has some medical debt, but those things came after date of separation. So I'm not quite sure. I'm confused as to why he would offer those things to you, because it doesn't pertain, I think, to our marital situation. And also, there were some discrepancies in the figures between his paycheck and so the income that he's getting. So I made my financial worksheet. I just went back to his pay stub and took the gross monthly and multiplied by 4 from his pay stub, because I couldn't quite figure out how Ms. Stewart and Mr. Hankins had their numbers on his paperwork. So I did my best to make it match the pay stub. And then as far as his dues go, there were some things I didn't understand but I also understand from just personal experience how they work. Let's see. Also, other things that I need you to know is that there are still $2,066.14 of mandatory education expenses awaiting reimbursement, and that's for this current school year. I have been getting some child support, but it has been irregular. The state prior to getting child support was very easy to work with and get information from. Now that they've started taking child support from his checks, they're not able to tell me all I can do to predict when there will be child support payments is based on the historical child support payments, not the current one. So it's frustrating from a budgeting standpoint. And then the first month that the state collected child support from Mr. Hankins, they collected something like $2,700. And because I was on TANF and I wasn't aware that Mr. Hankins was making the child support payments, state actually kept all of that as their TANF arrears, and I got $100 from that. So just to clarify, he is paying child support. I know that he is working hard at getting back on his feet. So I am getting child support. It's sporadic, and there's no planning. There's no schedule. You have all of the information. I don't know. What questions do you have for me?
What specifically, I know earlier but it's been a while and we've had, there's been a lot of things happen in the meantime. So what amount of specific support are you requesting? Earlier was like 2,500 or 2,300 or something like that. It was between 2 and 2,500. I just wanted to know, what are you requesting, today?
Sure. I would like the total payments between spousal support and child support to be $4,200 a month, and then have that adjusted as the children age out at 18 on the child support payments.
Okay. So you want maintenance to go up when child support goes down? Is that what you're saying?
Yes. We've been together 25 years, and that's a long commitment from my life to give into getting us where we are today. Okay. And also just so you know, the pension plan and the money purchase plan that we have talked about in the past in court, the money purchase plan a hardship withdrawal cannot be taken from it. So that's not even, it's not an asset that we can look at as potentially dealing with some of our financial situations. And the money purchase plan has a loan that was taken out on it, but it is in default. So until that loan is covered, that is also not a resource that we can deal with. I also have been working with Ms. Stewart in I've received a settlement offer from Mr. Hankins. I responded with a counter offer for Mr. Hankins. So that's also in the works, but we don't have anything. I haven't had a reply. They were busy this week doing other paperwork. So
okay. I can't know about settlement discussions. So,
okay.
And then attorney's fees, what was your request?
Well, I spent over $16,000 on a lawyer that I no longer have. And it's ridiculous. It would be preposterous for me to ask for all $16,000 to be rewarded to me. I realize that. So I'm just asking for what's fair and reasonable given our circumstances.
Okay. Thank you, Ms. Hankins. Ms. Stewart.
Thank you, Your Honor. For spousal support, what we want to do is look very closely at the financial declarations that have been filed with the court. And the financial declaration that we filed for my client indicates that his net monthly income is just above $6,900 per month, and that his total monthly expenses after separation, it comes out to be about, and I'm just approximating here, $5,400. Because he's got the payment on his medical debt. I want to clarify for the court that although that is his separate debt, we acknowledge that it would be characterized as his separate debt because it was incurred after the date of separation. It's still a debt that he is responsible for paying. So it has to go in his column when the court is evaluating whether or not he has the ability to pay spousal support. Because if the court takes my client's word for it on his household expenses after separation, and then takes his word for it on the debts that he's currently got that he's got to pay.
Hold on a second. Phones off, no phones. And everyone needs to be respectful. And if you need to leave, leave. If you need to talk, leave and talk. Okay. Got it. It's a small courtroom. So I don't want to hear murmurings from the gallery. If you have to talk, go outside. Thank you. Go ahead, Ms. Stewart.
Thank you, Your Honor. So the court has to take into consideration all of the debts that my client has the responsibility to pay. And although there have been issues with his ability to keep up on these payments, there's still debts that have to be paid. And if you look at Section 9 of his financial declaration, as well as Section 8 of his financial declaration at page 5 of 6, you're going to see a listing of all the debts that were not included above in the financial declaration. And those total monthly payments for those debts are over $1,000 per month, which if the court were to order the $4,200 that Ms. Hankins is requesting, that would leave my client with very little left over to be able to pay his living expenses. And I know that there has been some dispute about where my client has chosen to live, the amount of rent that he's currently paying, excuse me, but that's not really something that the court has to consider. My client selected what he believed was suitable housing in close proximity to his minor children, who he sees frequently. So the fact that he has to pay a lot in rent is just kind of the nature of the location where the parties are living. Excuse me. So with respect to, I'll start with the attorney's fees. Mrs. Hankins is accurate when she says that it would be probably not reasonable for the court to order my client to pay over $16,000 on an attorney that she doesn't have anymore. The elephant in the room, Your Honor, is the fact that local counsel was or should have been available to Mrs. Hankins to explore representation with, that this local counsel would not be billing over $600 or close to $600 an hour. I've never seen that kind of a billable rate in the area where her former counsel is located. Quite frankly, that's an hourly rate that I would expect a Seattle Seahawk to be paying his attorney. But in our county, just to put it in perspective, I mean, Miss Black has been practicing in this area for over 30 years, and her billable rate is $330. My billable rate is $275. So there were attorneys available in this area who have a more reasonable hourly rate, but that seems to have not been explored. And not for nothing, Your Honor, my client has also incurred an astronomical amount of attorney's fees in litigating this action. I mean, if you look at the last page of his financial declaration, you'll see that the amount that he's paid to date is over $17,800. The amount that he still owes is just under $5,000. So both of these parties are kind of in the same position in terms of how much attorney's fees they have incurred. The only difference is that Mr. Hankins has continued to be represented. Mrs. Hankins is no longer represented. So we're asking the court not to order any attorney's fees. On the spousal support, if the court is going to order any spousal support, I think that the court needs to really factor in how much my client's net monthly income is going to be after he pays all these debts. Because if the court orders too much of spousal support, what's going to happen is we're just going to end up right back before the court for another review hearing. And I want to avoid that because obviously these parties don't need to incur any more in attorney's fees than they already have. But what's missing in the record is the factors. We've got to go over the factors for spousal support. As the court is very well familiar with these factors, the court has to evaluate the financial resources of the party who's seeking maintenance, which includes separate community property, the ability to meet needs independently, including the provision for support of children living with the party who is requesting the support, the time necessary to acquire sufficient education or training, the standard of living, duration of the marriage, age, physical and emotional condition, and financial obligations of the spouse seeking maintenance. And then also very important is the ability of the spouse or domestic partner from whom maintenance is sought to meet his or her needs and financial obligations, while also meeting those of the spouse who's seeking maintenance. There's no doubt that this is a long-term marriage. These parties have been married for over 20 years. But what Ms. Hankins has not really emphasized in her argument is that she is a college-educated woman. There should be no barriers to her going out and finding some suitable full-time employment. And while we recognize that she would need time to do so, having been a stay-at-home parent for quite some time during this marriage, unfortunately, when you're going through a divorce and your working years are not yet behind you, the court has the expectation that parties are going to find suitable employment to support themselves, because it would not be fair or equitable for my client to have to essentially bankrupt himself paying spousal support while the other parent or spouse is voluntarily underemployed. I don't like that phrase. I think that it's probably difficult for opposing parties to hear, but that's the verbiage that we use in our courtroom. It's voluntarily underemployed when you're not working sufficient hours to meet your financial needs. So what we're asking the court to do is first and foremost deny the request for spousal support, because there's simply not enough money to go around. But if the court's going to order spousal support, we're asking that it be at an amount that's going to be doable for my client so that he's not in the red every single month after paying child support. Does the court have any specific questions for me?
I just had a couple quick questions for each.
Okay.
But I guess before I do that, Ms. Hankins, was there any brief reply? And then, like I said, I've got a couple quick questions just to verify a couple things.
Sure, absolutely. The college-educated comment, you'll notice that on Mr. Hankins' pay stubs, he's making $70.81 an hour without a college education. My rate of pay while substitute teaching, and that is with a college education, is $20 an hour. So I don't think that, bringing in my college education and saying that I should be able to go and do something and earn that kind of wage, I don't think that is an accurate representation of the situation in front of us. To find suitable full-time employment, yes. However, when this divorce began, and also right now, I'm under contract. Kevin and I had a contract where I would homeschool the kids. We are involved in a private homeschooling situation where I'm under contract to continue until the end of next school year. They're already starting the renegotiating and contract process for the 2025-2026 school year. And I have a commitment to my children and other children. So I can't just up and let that go because I'm suddenly finding myself in the middle of a situation due to domestic violence and divorce. You, Your Honor, have said yourself that it doesn't matter, and I agree, it doesn't matter how either one of us spends our money. You simply look at the bottom line on the paycheck. And when Ms. Stewart referenced Mr. Hankins' figures, I don't understand. I'm sure Your Honor can do the math, that his net monthly income would be $7,848.68. Not, I believe she had it down around $6,000. You, Your Honor, are saying that you are taking our word for things. I submitted to you my mortgage statement and the HOA fees, while Mr. Hankins simply is just putting a number on paper. The amount of debt that he continues to submit, his creditors differ. You can look back at the record each time that he's submitted financials. There are different creditors for different amounts. Granted, when you pay your debt, the amount is going to change. Mine have stayed consistent, and you can see where I am being responsible and doing my best to shave excess spending to take care of myself and the children. We also know that to say that I should have decreased spousal support because it would take away from his net monthly income to pay the bills. We know that he is comfortable defaulting on some of the bills. We know that medical debt has now been removed from the credit reports, as if you don't pay your medical debt, they're not going to bring your credit score down any. I have offered to go to the creditors with Mr. Hankins to ask for forgiveness, decreased payments, work on payment plans with him for both of our benefits. Also, paying medical debt is flexible. I realize if he wants to pay his medical debt, that's great, but it's not as stringent as paying credit card debts. So he would have leftover money for paying his living expenses. As far as the insinuation that I didn't do my due diligence in finding an attorney, I'm just going to, I don't have to defend my choices for an attorney. No one should have to do that. And I did do my due diligence, and I got representation that I needed when I needed it. The fact that Mr. Hankins' lawyer fees are growing is not my responsibility. I have since April or May of 2024 have continued to put forth options to Mr. Hankins to how we can come to a resolution on this. And that's, if someone wants to be difficult and argue it and continue to bring it to the court, that's their choice. So that is not my responsible either. And the factors for spousal support, to say that I'm voluntarily underemployed, yes, I'm definitely going to go on the record and say I disagree. And if you are going to impute my income or impute his income, let's keep it fair and equitable. If he's only working 30 hours a week, then my income should be imputed at 30 hours a week also. Let me make sure I covered everything. I think that's it, Your Honor.
Thanks. So I just have a couple quick questions. The first one is so Miss Stewart, you said you agreed your client's gross income is $9,200, right?
That's correct. Yes, I believe we put that in his financial declaration.
And then Miss Hankins, you said that the father's income is $9,700, $9,697, which call it $9,700. So there's about a $500 difference. Is that the extent, correct, on gross?
Yes, sir.
Okay. And Miss Stewart, you attributed $2,800 to the mom. Is that full-time minimum wage? It didn't indicate, because there's not a place, like on the child support schedule where you can say how you calculated stuff. So did you attribute it? Did you arrive at full-time minimum wage? Is that what you used?
Yes, I believe we pulled these figures probably from the child support worksheet where she was imputed. And on the imputation, my client's restricted medically to 30 hours a week. So it would not be equitable to impute him because, depending on the line of work, in some lines of work, 30 hours per week is considered full-time. But that, to answer your question, Your Honor, yes, I believe we imputed Mrs. Hankins at the minimum wage in the financial declaration.
And Ms. Hankins, you use $700 as the wages for you on your financial deck?
Yes, sir, because that's what my pay stubs reflect.
Okay. I just
And
want
that imputed
sure I
income
understood
is,
where.
okay.
So it's from the pay stubs?
Yes, sir. And you have those.
Yeah. And as far as it's just based on, I know that you, or at least you indicated earlier that you were also trying to get bus driving and a couple other things, but that was also on hold. I didn't get an update in a declaration format of anything like that. So that $700, that's just based on the substitute teaching and the library work, right? Or
yes,
the tier at the library. I wasn't 100% certain. I wanted to make sure I understood where the different incomes came from.
It's my library job. And then you have the last two pay stubs from the Quincy School District. Bus driving would be through the Quincy School District as well. However, those Quincy School District pay stubs are for substitute para-ing within the school system. And again, I have to work that around my homeschool schedule with the kiddos.
Okay. All right. Perfect. And then the last question, I just wanted to confirm how much, because I didn't see it
Sorry.
in any of the materials presented. And that's the current amount of child support that's being paid. I know it's in the file, but this file is like 8 files.
Yeah,
thick.
it's supposed to be 18,
I think that-
18.
I think that's right. Yeah, I think that's right, Your Honor.
It's how much?
Supposed to be 1863, I think.
That
Okay.
sounds correct, Your Honor. I don't have the order in front of me, but that's ringing a bell.
Okay.
And that imputed income was definitely higher on the spousal, on the financials this time than it was when it was imputed for child support.
Yeah.
I got a raise, a proverbial raise.
Okay. Well, that's what because I had the DCS thing, but that was it doesn't show everything. And Miss Hankins, are you off of TANF now or not?
Yes.
You're off of TANF? So
Yes.
you're receiving the child support.
Yes, but like I said earlier, it's
Sporadic.
it's not regular. And the state won't tell me, oh, like when you have a paycheck, you're getting paid on the 5th and the 25th. When it comes to child support, they won't tell me when it's coming.
I understand, because it depends on when they collect it and when he's working and
Yes.
he's working 30 hours. I mean, I understand that he's working union jobs, so it's not like the same place necessarily week in, week out, working for the PUD or the school district. Okay. All right. So like I said, this was a big docket. I did review the materials. I've heard from the parties. What I'm going to do is I'm going to set this over for it'll probably be the court's oral ruling, because I doubt I'm going to be able to have time. I got big dockets for the next 3 weeks before Thanksgiving to be able to get out a written decision. But I can set this over either 1 or 2 weeks for just an oral ruling. Obviously, if the parties can't be here, they could always get it off of they could request a CD and listen to it. But are both parties here in 2 weeks on the 15th available to listen on Zoom?
I am, yes, Your Honor.
It would depend on the time, Your Honor. I do have a substitute teaching job at New Life Christian School. So what would the time be, sir?
It'd probably be at 9, but I don't know when we get to it. It's a big docket.
No, sir, I wouldn't be. I can ask. I mean, can I have my sister sit in for me if she's available?
Well, there's a couple options. Like I said, I'm just going to give the ruling. I'm not going to take any argument from anyone. I'll just issue the ruling. You can listen to it. But what about Thursday? We could do it on the paternity docket.
Next Thursday, Your Honor.
Thursday, we could do next Thursday or the 14th.
I am completely free next Thursday.
I am available afternoon, sir. Any of those days would have to be after 12 o'clock.
Okay. Well, the docket's in the morning.
I mean, if all the court is doing is issuing its oral ruling, I mean, the court's not taking any argument.
Yeah.
So, I mean.
No, I understand. So, Ms. Hankins, as far as a docket, I mean, if I suppose I could put it in the afternoon on one of those dockets on the Friday, but it's just a matter of, typically it'd be, it's on a Friday morning, or I can put it on a Thursday morning at 9. Are there any Thursdays or Fridays that would work for you at 9? Thursdays, it'll be fairly quick at 9. Fridays, it's who knows. Week was bad.
I would just have to listen to the CD, I suppose.
Okay.
No, I'm in appointments at 9 o'clock.
Okay. What I'll do, I'll put it on the 14th, Thursday the 14th, for an oral ruling. That does give the parties at least, Ms. Hankins, it gives you a couple weeks. If you can make yourself available, great. If not, You can order the CD from the clerk's office. They do charge $30 or $35 to get the CD, but you can listen to the recording. So, but I'll set it out to the 14th, so that if people want to rearrange schedules, they can, at least a greater ability than trying to do it Monday.
Okay.
So, okay. Yeah.
Well, what does that mean? So what am I what's going to happen what are you ruling on the 14th?
The rule on the finances here.
Okay. And those are temporary from
Maintenance and temporary attorney's fees.
Okay. From the January motion through now.
And most likely it'll be temporary moving forward to trial. I don't know if I'll order any back. I'll just probably reserve on that to the trial and or settlement, but we will get an amount set going forward, probably from November on, but I don't know.
Okay. Will it also be written, Your Honor, or only orally? Okay.
It'll be oral.
Okay.
You got to get the Queen's English all right and send out the written ruling. It just takes a lot longer. I can write it out, but I'll be able to read it and not have all the grammar perfect, commas in the right places and stuff like that. So,
okay.
the 14th.
Thank you, Your Honor.
Thanks.